Call the third case on this morning's docket, case number 113869, State of Kansas v. Stephen Allen Macomber.
May it please the court, Stephen Allen Macomber, appellant, appearing by Jonathan Phelps. I'm asking for 3 minutes of rebuttal.
3 minutes is granted.
Thank you. This case originated on June 7th, 2010 in southeast Topeka, Shawnee County, Kansas, when Mr. Macomber shot and killed Ryan Lofton. We're at this court today on a petition for review from the Court of Appeals following a conviction for involuntary manslaughter in the district court. There are two primary issues, both relating to immunity for self-defense, that we intend to argue today. Now, this is the second trip to the appeals level on this case. Originally, after being charged with second-degree murder and being convicted, his original conviction was reversed by the Court of Appeals, and it went back down to district court. Now I'll begin my argument, please. Yes. King Solomon, in a very similar context to this case, said that jealousy is the rage of a man, therefore he will not spare in the day of vengeance. That rage is what brings Mr. Macomber to this court today. He is here to ask for your protection from that rage in at least one of two important ways. First, he asked that you order the district judge to grant him immunity from prosecution when he shot Ryan Lofton, who was seeking vengeance on him. Short of that, he asked you to send this case back with an order to the district court that they must give an instruction to the jury during his new trial that he is presumed to have used reasonable force when he shot Ryan Lofton on June 7, 2010. This is the second time in the last 9 years that Mr. Macomber has sought an appeal in this case. First time on different grounds, his conviction for intentional second-degree murder. The killing of Ryan Lofton was reversed. Upon remand, he sought immunity from prosecution for self-defense. The district court, after holding a hearing, considering the evidence from the first trial and the arguments and evidence presented at the motion hearing on his request for immunity, denied that motion. At trial, he sought a jury instruction that his force was presumptively reasonable. That proverbial rage spoken of earlier came to life on June 7 and like a tsunami flooded into Macomber's vehicle, which he occupied at that time, June 7, 2010. Because he was invited and requested to pick up Risa Lofton, Ryan Lofton's wife, from their marital home in southeast Topeka. Macomber, because of a recent spate of shootings and killings in that neighborhood in the late spring of 2010, had a .357 gun with him in the car, and it was inside a Crown Royal bag as he traveled to that home to pick up Miss Lofton. When he arrived at the home, he pulled his vehicle into their driveway and parked it. Her husband, Ryan Lofton, high on methamphetamine and raging mad at his wife and at Macomber because he suspected she was being unfaithful and that Macomber was the object of her adultery, followed Risa Lofton out of the house as she carried her bags to Macomber's car. And as she put the bags in the car and got in the car, he loudly argued and demanded that she not leave, and among other things, called her a whore. Risa Lofton got into the passenger front seat of Macomber's vehicle, and after he was unable to get her out of the car, Ryan Lofton went to the driver's side of the car and confronted Macomber, verbally and physically. Lofton was there to seek vengeance and to vent his rage of jealousy. Ryan Lofton forcefully and unlawfully attempted to enter and did enter the vehicle on the driver's side through the driver's side window. in the car McComber occupied, reached inside the vehicle, attempted to unlock the door, tussled or struggled with McComber, grabbed the gun McComber had retrieved, still covered in the Crown Royal bag. He threatened McComber that he would shoot McComber. In that struggle, McComber fired one shot in the direction of Ryan Lofton with that .357 gun. McComber was struck and died as a result of that gunshot. He asked for immunity from prosecution pursuant to KSA 21-5231. After hearing, considering the evidence from the first trial and evidence and arguments presented at the hearing and the filings leading up to the hearing on the motion for immunity, the district judge denied the motion for immunity. The court ruled that when considering a defendant's, this court has ruled that when considering a defendant's motion for immunity under this statute, the district court must consider the totality of the circumstances, weigh the evidence before it without deference to the state, and determine whether the state has carried its burden to establish probable cause that the defendant's use of force was not statutorily justified. In the same case I'm referring to, State v. Hardy, they ruled that when rendering probable cause determination pursuant to this statute, the district court must consider the statutory presumption set forth in KSA 21-5224 when they are factually implicated. Now, that statute provides a person is presumed to have a reasonable belief that deadly force is necessary to prevent imminent death or great bodily harm to such person or another person if the person against whom the force is used at the time the force is used is unlawfully or forcefully entering or has unlawfully or forcefully entered and is present within the dwelling, the place of work or occupied vehicle of the person using force, or has removed or is attempting to remove another person against such other person's will from the dwelling, place of work or occupied vehicle of the person using force. Now, an appellate court will apply a bifurcated standard of review to a district court's determination of probable cause pursuant to KSA 21-5231. When the district court's ruling entails factual findings arising out of disputed evidence, a reviewing court will not reweigh the evidence and will review those factual findings for supporting substantial competent evidence only. The ultimate legal conclusion drawn from these facts is reviewed de novo. McComber argues that the court's findings give great deference to the state, are not supported by substantially competent evidence, and the court's rulings fails to consider the presumption of KSA 21-5224. This is shown in two significant ways. The trial court found that McComber's statement that Ryan Lofton had threatened to shoot him was not a credible statement, and that defendant's version that Ryan Lofton was reaching into the car when the gun went off is not supported by the scientific evidence or the facts in this case. There's quite simply, the court went on to say, a break in time between Mr. Lofton reaching into the car to when Mr. Lofton was shot. These findings of the court are not supported by substantial competent evidence, the details of which are set forth in the briefs filed with the Court of Appeals, which include that it's undisputed that McComber never left his car and that Ryan Lofton was shot during a struggle that occurred in and at the threshold of McComber's vehicle. Dr. Pullman, the coroner, agreed that it was possible, that is, it was compatible with the scientific evidence, that the gunshot wound to Lofton was consistent with the physiological path the bullet traveled through Lofton based on a scenario of Lofton reaching into the car and pulling the firearm and releasing it as he was pulling. Dr. Pullman's testimony was that he could not determine the range of fire, but did exclude a contact wound. The gun was inside a Royal Crown bag when fired, and so the typical stippling, which would appear around the wound from a gunshot fired 18 to 36 inches away, did not appear on Mr. Lofton. However, close range shot was not excluded by the scientific evidence. At the trial, Mr. McComber requested an instruction which recited the presumption to the jury contained in KSA 21-5224, and it was an approved PIC instruction. The trial judge denied the request, stating that Mr. Lofton was not presently within the occupied vehicle when he was shot.
Counsel, because the judge wouldn't give the presumption instruction, was the defendant prevented from introducing any evidence?
No.
Counsel,
Yes.
while you're interrupted, my understanding of your recitation indicates that this .357 Magnum was inside this Crown Royal bag when the gun discharged.
Yes, sir.
Is there any evidence that any material or fabric particles from that bag appeared on the victim? You said there was no gunshot residue or stippling, anything about the fabric.
No, there wasn't. There was evidence from at least one expert hired by the defense that the gun or the bag had signs of gunshot through it. And the manner in which they found the bag and the gun be consistent with it being fired through that bag. But your specific question, no.
Thank you.
Now, the judge's rationale for not
Let
giving...
me follow up on my question. So walk me through the harm you see from the failure to give the presumption instruction. You weren't prevented from putting on any evidence. You weren't prevented from making any arguments, as near as I can tell from looking at things. But so why are you hurt?
Well, the presumption is in effect for a reason. And when the defense presents their theory that they were acting lawfully and in self-defense, they certainly would have had a substantial, they should have had the benefit of a statement of the law that in fact there's a presumption his force was reasonable under these circumstances.
Isn't that covered by the presumption of innocence that applies to all criminal cases?
Certainly, but when you're talking about a situation where a person must establish that they acted in self-defense, the presumption that he acted reasonably would have been a substantial benefit to him at the trial of this case.
But the burden never really, the burden of proof never shifts to the defendant.
That is correct, but
The state has to, the state has to prove the absence of a reasonable belief, right?
right. But if a jury who is going to struggle with these facts going to be told that there's a law out there that says this was presumptively reasonable, that's a substantial benefit.
Just because it zeroes in on a particular element of the defense? Is that your basic argument?
Basically, and
Okay.
And it rises to the level of the government having to establish, we believe, that it was no prejudicial error beyond reasonable doubt because of the constitutional right to a fair trial due process to have the theory of his case articulated to a jury in the form of instructions, as was requested in this case.
If we disagree with the constitutional error and say that it's a state law error which has a lower threshold, are you still harmed? What's your argument there?
It's essentially the same argument. Just like to federalize it when we can. It's my position. Federalize the issue. Thank you.
Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Jody Litvin. The state's position here is that both the district court and the Court of Appeals was correct in the determination that when the district court denied his request for the use of force presumption instruction, and when the district court denied the defendant's motion to dismiss based on immunity from prosecution. I'll start with the first issue, which would be the use of force presumption instruction. He did request this instruction after the second jury trial. The state responded, the court ruled and found basically that this wasn't factually appropriate. And the state agrees with that conclusion. Unless it's factually the presumption instruction is triggered when at the time the force was used, i.e. when Macomber fired his shot, Ryan either was unlawfully or forcefully entering Macomber's car, had unlawfully or forcefully entered and was present within. I think we can take out that second option pretty easily because there was no evidence that he had ever entered the car and remained within at the time he was shot. But as the Court of Appeals does point out, there was a lot of conflicting evidence as to whether Ryan ever was inside of the car. But our position is still, even in the light most favorable to the defendant, there wasn't evidence that he was entering, unlawfully or forcefully entering Macomber's car at the time that he fired the shot. And from the state's view, the only evidence that we can see that actually supports that is Josh Canoli, I believe. I'm not sure how to say his name, but he had told an investigator that Ryan had reached into Macomber's car, and the investigator was doing some motion at trial, and they tried to get him to describe what motion he was doing, and he described that as pushing and pulling motions between Ryan and Macomber. And then, importantly, Canoli looked away from the car and back towards the house when he heard the gunshot. So at most, we have possibly a reaching in, but he still did not see where the victim was at the time the force was used.
Does it have to be precisely simultaneous? Is that really your argument? If it was seconds separated?
I think it's important because the instruction does say at the time the force was used. And if there was a break, because other evidence shows...
But it just seems illogical if the break is a split second or 2 seconds.
Well, I think it's important because if he's turning, if the victim had turned, like one witness said that she thought he was turning to walk away, I think that's important. Because obviously you're not entering the car if you're turning away, and I think that's a big difference.
And one witness said that. It looked to me like the witnesses were a little all over the place, really, even on the side of the car. I mean, there was conflict there.
I agree.
I just don't know what harm it would have done the state to give the instruction, and it seems like your stronger avenue here is to say it wouldn't have done the defendant any good to have it either.
Sure, and that's that's my second portion of the argument.
Plan B.
It doesn't.
Harmless.
Yes, and we would agree that it would be the statutory harmless error analysis because he was allowed to present his defense. He got a self-defense instruction. It was argued, so we don't believe that he was denied his right to a defense. But yes, I completely agree. I just wanted to note that I don't know that the Court of Appeals ever said it was error not to give it. They just said it was a close call, but it wasn't reversible. So we agree with that analysis as well as
They
it doesn't
just
change.
jump to harmless.
Sure.
Which they do sometimes, so do we. Make the harmless argument, though. Granularly. Tell me why this was harmless. Because I am actually bothered. I'll just fess up. I'm bothered by the impact that it might have on a jury to have the benefit the defendant would get if you're telling him, hey, there's a presumption here that it was reasonable. If you think he was reaching in. I understand your timing argument, but just walk me through why this was harmless given what you have in the evidence that's been presented.
Sure, and I guess I would just go back to what the Court of Appeals talked about, that the presumption is rebuttable. So I think if this was a conclusive presumption or an irrebuttable presumption, we would be in a different position. But it's rebuttable, so the jury doesn't even have to accept. The jury is instructed that that presumption is not conclusive. And then the district court or the Court of Appeals looked at Pennington versus State, which talks about how this presumption doesn't substantively change the law on self-defense.
That's the legal argument, though. And I want to move past the legal argument and talk about the evidence in this case that would indicate that this was harmless error. It's a legal argument. The Pennington argument that the Court of Appeals uses is legal. Hey,
Yes.
this guy's got a presumption of innocence. State's got to prove by that's all legal. I want to know whether there's conflicting evidence or not conflicting evidence so that the jury would have disregarded the presumption instruction and still convicted this guy.
And to my understanding, that would go back to my argument of we have to look at exactly what evidence we had of the victim reaching in or unlawfully or forcefully entering the vehicle. And I don't think that's there. I think that just goes back to my timing argument, I guess, as to the most, if we read it in the light most favorable to the defendant, the most we have is a possibility that his hand went inside the car, and we'd have to say that the jury thought that that was unlawfully or forcefully entering to get McComber out, I guess. I mean, because he said he was going for the gun, which I think that was what the defendant said, and that his hands were not on the gun at the time he was shot. So it would just be, factually, the jury, I guess, would have to focus on, was there a possibility that he reached his hands sometime in the car, that the window was down, which there was never any solid testimony as to was the window down or was it cracked some inches or not. So I just don't think that the facts are there to support that. I guess that's the best answer I can give.
Can you remind me of the evidence about how the bullet hit the victim and what that told us about his position at the time he was shot?
And that was confusing to me too, Your Honor.
Okay.
Because Pointman
if it's
first,
confusing, then maybe that's all I need to know. It's not hard and fast. It's not clear and undisputed exactly what the trajectory was. Or
well, he gets on it and then comes off it, I think. So Pointman says he was shot in the back under his left shoulder blade. And the trajectory, or it goes slightly from back to front. And then it goes from left to right. And then he kind of changes and says, but if the gun was in the defendant's right hand, it could be more to the side than to flat back. But I don't think he ever changed his position that the entrance wound of the bullet was on his, I think the way he described it was through his back, to his chest, through his back, under his left shoulder blade.
Okay. And the witnesses, we've already talked about, you and I, that they were kind of all over the place about who was where, when. Did any of them get specific enough to say which arm or both arms of the victim were at one point extended into the car? Did any of them get specific about which side of the body his arm came from?
Not that I recall, Your Honor.
Okay, I didn't remember that either, but I thought you would know better than I. Thanks.
Yeah, just from what I remember, it was a
and there's-
possibility of an arm.
Okay.
And there's no evidence of a hole through the window or a shattering of the window or anything about the condition of the window?
I don't believe there's any evidence as to that, no. We've got one witness saying the window was down. We've got one, Rissa, who was in the car, the passenger seat of the car, saying the window was down a couple of inches.
But when we have testimony all over the place, to use my colleague's description, and that you seem to agree with, why haven't we created a jury question? And unless, what I hear you saying, unless reaching in the car doesn't fit within the definition of forcible entry as a matter of law, and I don't agree with you on that. In fact, I think we have a court case where, one of our cases, where someone was had their head in the car. Unless that's excluded as a matter of law, why isn't it up to the jury to decide who got closest to what was actually happening?
I think the district court has a gatekeeping function, or when it's a jury instruction request, the judge has to make the determination of whether it's legally and factually appropriate. So I think that stops with the judge there. If he finds it wasn't factually appropriate to trigger that instruction, it doesn't get to go to the jury.
But the judge is not the fact finder. And I understand that if there's no evidence that would reasonably support a jury's determination that he was forcibly entering, but I don't hear you saying that. I don't hear you saying that there was absolutely no evidence, no testimony, or no reasonable inferences from testimony that would exclude the victim having entered into the car with some body part.
I think that I agree that there was some testimony that it was possible that his arm was inside the car at some point. But I think that, just to be clear, the state's position is that that doesn't make it factually appropriate to give it here, because there wasn't any witness who could nail down the time, and whether you like my timing argument or not, as to at the time the force was used, so at the time he was shot, where was the victim's hand? And no one can say for sure. And that's what I think triggers the presumption argument.
Could you?
And I thought
No,
I
go ahead.
thought this whole line of inquiry was started by Justice Miles asking you to talk about reversibility. Am I wrong? The last several minutes, isn't that what we've been talking about? assume that it was error not to give the instruction, what does that mean to your case? And I thought your answer to his question was, well, we would start with what the instruction or the statute would require, and we would say that wasn't done. But then in addition to that, were you commenting on that, or did I misunderstand what this colloquy was?
I think I would agree that my argument for reversibility goes back to I don't think it was factually ever appropriate.
I understand, but I thought you were starting your harmlessness answer by saying, well, first of all, the evidence at best from the witnesses is that there was a hand possibly inside the window. And so there is no evidence of lawfully or forcefully entering.
Right.
Or if there is such evidence, it's not very strong. Is that what you're telling us?
Yes, I think so. I think
Okay,
so.
I'm not trying to put words in your mouth.
Right.
I'm just trying to understand what you're saying.
I think that's
Okay.
correct.
Okay. Well, let me go back to the question that I asked opposing counsel and his response. And it goes back to what sort of evidence that a weapon had been discharged against the victim was there other than a bullet hole in him? In other words, was there any residue, any stippling, any fabric from this Crown Royal bag, anything that would tell us that it in fact was shot through this bag other than residue inside the bag? I'm trying to get a feeling for how far away from the vehicle he was when the bullet entered his body. Can you elaborate on that for us?
I can point you to Dr. Poyman's testimony, I can point you to Rissa's testimony, which says she saw the butt of the gun sticking out of a Crown Royal bag. So we have her seeing a gun inside of a bag. And then Dr. Poyman apparently didn't have the information that the gun was covered with a Crown Royal bag, to my understanding. But he said there was no stippling and there was no soot. And that could be caused because it was either 24 or 36 inches away, at least 24 or 36 inches away, the victim was from the shooting, or that there was some other clothing that he wasn't sure. It could have been caused because there was more clothing than he knew about. So he did make the determination, though, that it wasn't a contact wound, right? Up against it, and it wasn't a close range shot. So it was an indeterminate range. So
And did he specify what an indeterminate range is, or it's beyond a close range is X and therefore indeterminate is Y? Are we left to figure out for ourselves from the record, if we can, how far away from the vehicle the victim was when he was shot, or whether he actually was up against the vehicle?
Right.
Can we tell anything from any of this?
my best answer, Your Honor, from what I remember from the Dr. Poyman's testimony from the second trial is that the way he described it, he excluded the contact wound, he excluded the close range and said it was indeterminate, and that the 24 to 36, it had to be more than 24 to 36 inches away. That's what would get it in the indeterminate range. I thought there was an answer that he provided on the state's questioning that clarified that.
But isn't it, normally the stippling would be pretty good evidence about where he was.
Sure.
And am I correct, though, that because we've got the unknown factor of the Crown Royal bag that might explain why there's no stippling, that we're still sort of throwing our hands up in terms of where the victim was in relation to being in or out of the vehicle at whatever time, right?
I think there still is conflicting evidence, although I think the majority of the witnesses testify that he was standing near the car and not touching the car and not inside the car. But again, we've got a lot of conflicting evidence.
Right.
His head was in the car,
I'm looking for something that tips the balance for you, and I keep running into a conflict. To me, the strongest part of the evidence is the defendant's own statements about what was happening with the victim. I mean, it's one thing to have everybody else not knowing, but the defendant's sort of making some pretty strong statements. That's what I'm weighing. I mean, I'm just trying to give you a chance to work
Right.
on me before we'd get this done.
Yeah, and I think he did say to the special agents that, he was talking smack or something like that, and I shot him. Or he said he threatened to shoot me, so I shot him first. So I don't know that even in his own statements, I don't want to say that. I think he did say that he reached for the gun, but at the time he shot him, his hands were not on the gun.
Right.
So
Before you sit down, I want you to at least address the second issue, and that's the self-defense immunity. And what I'm struggling with is if the instruction on the reasonableness is appropriate, what's the line between that and the self-defense immunity in terms of whether Macomber reasonably believed deadly force was necessary to prevent? That's when the self-defense immunity comes into play, and it seems to overlap with the instruction, with whether or not the instruction's warranted. So I'm wondering if the instruction's warranted, what precludes the self-defense immunity from being asserted and granted? What's the difference? What's the line?
right. Well, I took it as two different things because if we're already at the jury trial and we're talking about an instruction to get to,
I understand that, but if it's warranted, if the instruction's warranted, why isn't self-defense immunity come into play here?
maybe because the presumption is rebuttable, and if the state can still establish probable cause the defendant's use of force was not justified.
Isn't part of the answer also that at the immunity stage you're at probable cause as
Sure.
opposed to proof beyond a reasonable doubt?
Sure.
Yeah, no, I understand that, but there seems to be a pretty close tie to the two, anyway.
And I think that not having any guidance from Hardy, that the district court did a correct analysis here and didn't weigh. He looked at the totality of the circumstances, and he did talk about the presumption, I think, for Macomber not to have a duty to retreat. So there was some language about he was considering presumptions. Judge Debenham certainly weighed the evidence without deference to the state and considered the preliminary hearing, the first trial, the immunity hearing, and took all of that into consideration. And then we also believe that his factual findings were supported by substantial competent evidence and would turn to the Court of Appeals opinion for that reasoning. And I'm out of time, so I have no further presentation, Your Honor.
Any further questions? Thank you, counsel.
May it please the court, the Dr. Pohman's testimony was that it was not a contact wound, and he was unable to determine the range of fire. However, at the autopsy, he was never made aware of the undisputed fact that the gun was in a Crown Royal bag when discharged. And he testified that an intervening material between the barrel of the gun and Lofton could impact the range of fire determination. Risa Lofton testified that she was getting out of Macomber's car to push her husband out of the way. Now, we do have pictures of the scene of where this event occurred, and there's clearly no broken glass. There's no witness that reported broken glass at any stage of this process. So we have evidence that the window was down. The last thing I would ask to speak, I want you to consider, please, that this gentleman is sitting in this car with a gun in his hand, and this individual has acknowledged that he had the gun in his hand. And other witnesses said, "What are you going to do? Shoot?" That he said, Lofton said, "What are you going to do? Shoot me?" And then, so what? I think it's fair for us to make an inference that Macomber had the belief that he was going to grab his gun and shoot him, and that was the activity that the back and forth tussling was over.
But that doesn't get us to the instruction that we're arguing about, the presumption instruction. And it says you get the presumption only if, and the first factor, there's two factors here, but the one I want to focus on is at the time the force likely to cause the death or bodily harm was used, the individual was entering and presently within the occupied vehicle. And what's the evidence that when he used the deadly force, the victim's was reaching inside the vehicle at the time the force was used?
All of this that I've said before and the reality.
Walk me through it.
Okay.
Tell me, who's saying that
This
guy
guy
is
was-
inside the vehicle.
First of all, this guy was mad, and he
I
was
don't
going
care
from
about that. I
one-
want to know that
went to the
some part of his
passenger's
body was in the car.
went to the passenger's window, then he went to the driver's side window, and he reached in that, and he was grabbing that gun and talking about shooting.
Who says that?
McComber says that. The witness,
And this is at the time the gun's fired. Your client is making the statement that the arm was inside the vehicle.
that's right,
That the victim was inside the vehicle.
that's right, and not only that, but I don't think that you can, in these types of situations, you can split that hair that much, because he's at the threshold of this car at a minimum, and
The instruction you want says presently within the occupied vehicle. So
Certainly.
I'm not splitting hairs. I'm simply reading what the instruction is that you want.
right,
And I'm trying to figure out how you get a jury question on that.
okay. The Pullman's testimony, I've done the best with that. I have a little additional information that may help. Pullman's testified that the entrance wound was closer to his side than the back. So that's that reaching motion into the car where it enters under his armpit. I have that additional piece of information. Now, with respect to how the final argument is, how was my client prejudiced by not giving this instruction? Without the presumption instruction, the jury must make a determination of the use of deadly force that it was objectively reasonable. Pennington did not consider that the presumption of innocence and the objective prong of the self-defense test are incongruous. Objectivity requires evaluation without distortion or prejudice, nullifying the deference the presumption of innocence implies when evaluating these facts for their reasonableness. The presumption of reasonableness instruction is substantive because it eliminates a need for the jury to make an objective conclusion if certain predicate facts are found. Even if this presumption is rebuttable, there is not a reasonable probability that the jury would reject this presumption because they were never told that if they believed that Ryan Lofton was unlawfully or forcefully entering or had entered and was present within McCormick's vehicle, that his use of deadly force is presumed reasonable. It's a vital piece of information based upon all of this evidence, and the right to present a defense and to be instructed on the defense, properly instructed, are inescapably intertwined for due process purposes. Thank you very much.
Counsel, I'd like to follow up
Sure.
with a question or two in response to my colleague's question about what evidence you had to support this instruction. I think maybe he asked it in terms of what's your best evidence or who testified to it. My notes indicate that you told us that your client version is that the victim was reaching inside the car when the defendant pulled the trigger.
Right.
Is that right?
Yes,
Okay.
sir.
And given that, in looking at the statute, are you saying that that therefore is demonstrating that at the time the force was used, in other words, the trigger being pulled, the victim was forcefully entering the occupied vehicle?
Yes, sir.
All right. It's your view you don't have to actually be inside or to open the door, reaching inside is sufficient?
Yes, sir.
All right, thank you.
Well, Mr. Phelps, on that point, let's change the facts a little bit because let's say an individual is trying to force his way into a house and he hit the door with his shoulder.
Right.
He backed up, it wasn't enough, so he backed up and he wanted to really hit the door. And as he was doing it the second time, was going forward, hadn't entered, wasn't entering, but he was trying to break the door down to do those things. Does your self-defense apply to that?
I believe it does.
Why?
From a practical standpoint, because since law school, we've been arguing about this threshold thing, and a reasonable person doesn't have to wait to be confronted immediately with death or what is that harm that is presented there to take some steps to defend himself. That's my best answer. Okay.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement